in labor relations, there's a comfortable relationship generally between arbitrators. About 30% of the practicing arbitrators are non-attorneys. So it's not, I'm not that rare, but a majority of them have legal training. And just based on informal discussions with learned counsel here in Minnesota, my impression is they're a little more concerned about these changes than the non-attorney arbitrators are. And I think when I get to that part, and this so-called implied attorney bias that appears in the statute, I'll tell you. If anybody really wants to look at this, I copied this out of the statutes, and this is the change. And the changes were significant, but most of them have very little impact on us. First, a little history. The Uniform Arbitration Act is a federal statute, and it is one that states may opt into to comply, can adopt in whole or in part. Minnesota, way back in 1955, way before there was any collective bargaining in the public sector to speak of, adopted, the legislature saw fit to adopt the Uniform Arbitration Act and say, this is a good statute, we're going to adopt it in total and incorporate it into Minnesota statutes, which is what they did. By the same token, they incorporated a lot of these changes, the so-called revised Uniform Arbitration Act of 2010. Again, they bought in, said that works. Now, it's important, the history is important because there are lots of arbitration, types of arbitration that are covered by the Uniform Arbitration Act. In fact, labor arbitration is just a little piece of the whole scope of this. Commercial arbitration is by far the largest and the one where the big money tends to be involved, where there are disputes between companies over contractual issues. Insurance arbitration is a major part of commercial arbitration, and there's if you've got an insurance contract of some kind, you probably signed an arbitration agreement. You buy a new car, you've signed an arbitration agreement to arbitrate any disputes with the employer. So, and in real estate, we're seeing it very commonly. As part of the closing, you agree to arbitrate any disputes with the seller, if you're the buyer. So there's a lot of stuff that goes on. There's also a lot of what we call community dispute arbitration that is handled. Your neighbor's got a fence on your property, or you got a barking dog, or you've got a local dispute that can be resolved much more cheaply and efficiently through arbitration. And then there is the area of employment arbitration. And that's where a lot of this, I believe, is coming from, a lot of the impetus for the change. Employment arbitration is a relatively new business. It's different than labor arbitration. It's not the same thing. It's the kind of arbitration that typically employers will impose, sometimes contractually, as a condition of employment. It basically says that when you sign on at XYZ company, you agree to submit any dispute arising out of the course of your employment to arbitration. And there have been some real problems with that. We had an issue where the Attorney General in Minnesota a few years ago actually sued one of these arbitration providing associations that had signed up with employers, and they found that it was coercive, that employees or people who were being compelled to arbitrate were not fully informed of their rights. And frankly, it is flat out coercive. I mean, you come in and you're offered this wonderful job that you've been looking for, and you're told, well, by the way, you know, we have an arbitration provision here, and while they may not say it, the message is, you want the job, you sign the agreement. By doing so, you waive your right to sue, because that is the critical element in arbitration which makes it so attractive to employers. Labor was the only kind of arbitration that we had, and you didn't get arbitration anywhere unless you had a collective bargaining agreement, and it was pretty much widespread under all collective bargaining agreements, has been for the last 60 years. But beginning with EEO and EEO complaints and suits, and with the litigious nature of employment, employees suing their employer for wrongful discharge, alleging discrimination based on gender or age in particular, a lot of employers simply said, we're getting burned on this. We're in a situation where we're going to lose, or we're going to lose big. Because, you know, even though we believe we have a case and we can prevail in court, we're still going to end up going to court. It's going to take a long time. And many employers simply said, look, pay them off and get rid of them. We don't believe this complaint has merit. This employee clearly could not prove his or her claim in court. But it's going to cost us more money to defend it than it is to offer them a few $1,000s a year's pay and get them to go away and waive it. And employers got tired of doing that. And so what we started to see, and all the big management law firms in town that handled employment issues were saying, put in your own arbitration provision. Control it. Make it compulsory. Get employees to sign up. And once you have a written agreement to arbitrate, under the terms of the Uniform Arbitration Act, the court can then compel arbitration. You're now under a different legal doctrine. We understand stare decisis, the decisional law. You get a dispute, you end up in court, you don't like the result, or you think there was an error, you appeal and it goes to a higher court. Might end up in front of the Minnesota Supreme Court, or if it's a federal issue, might end up in front of the US Supreme Court. And then when that court is spoken, that becomes the law of the land. But it's based on decisions of higher courts. And people don't always appeal. The appellate courts handle a lot of these. They issue the decision. Parties say, all right, we're going to accept that. We're done. Arbitration doesn't function under that doctrine. It's under a doctrine called Resjudicata, which essentially, I won't give you a literal Latin translation, but basically it's over, it's finished. There is no appeal. And the grounds for appeal in arbitration are minuscule. Only about 3% of all arbitration awards get appealed, and very few of those are overturned because the grounds are so very, very limited. Grounds for appeal are simple. One, that the arbitrator exceeded his or her authority. That's the most common. Secondly, that the arbitrator was incompetent. And that means legally incompetent. Essentially, your burden there is to prove that the arbitrator should have been at the funny farm rather than hearing your case. That he had lost his or her mental faculties and was incapable or incompetent to register a decision. Not because he didn't like you, not because of how he ruled on the evidence, not because he was wrong, but because he was not competent. I'm not aware of it.
Not a bad arbitrator. It doesn't matter if you're a bad arbitrator. You just have to be a
crazy
one.
Mentally competent. And that is, that one goes nowhere. The third basis is that the arbitrator engaged in some sort of misfeasance or malfeasance. Typical malfeasance would be somebody paid the arbitrator off in advance. Look, we'll give you $1,000 if you decide this one in our favor. That sort of thing. It doesn't happen, it's rare, but it would be a basis for appeal. Misfeasance is tougher, and it's one of the issues that is clouded up by the new act. Misfeasance is the arbitrator fails to do something that he or she should have done within the scope of their office. An arbitrator's scope of office arises when he or she is appointed, and it ends when he or she signs their name at the end of the award. And they have no authority before and none thereafter. So, but when it is before the arbitrator and within the arbitrator's scope of authority, they have significant authority. So it is at that time that the arbitrator could engage in some sort of misfeasance. But failure to disclose can be a major problem for arbitrators, and there are all kinds of tricky issues. I could probably give you a whole laundry list of strange situations where an arbitrator is sort of compelled to say, do I disclose this or not? Is this something that the other party really ought to know? So disclosure is a problem, and I'm going to come back to that because there's a specific provision in Section 12 at 572B, which talks about disclosure by the arbitrator. And it says, quote, before accepting appointment, an individual who is requested to serve as an arbitrator, after making a reasonable inquiry, whatever that is, shall disclose to all parties to the agreement to arbitrate and arbitration proceeding and to any other arbitrators any known facts that a reasonable person would consider likely to affect the impartiality of the arbitrator in the arbitration proceeding, including financial or personal interest. An existing or past relationship with any of the parties to the agreement to arbitrate or the arbitration proceeding, their counsel or representatives, witnesses, or the other arbitrators in case of a tripartite panel. So those are the grounds, that's it. You don't get a lot of appeals won. But once you have moved into arbitration, you have waived your right to sue and essentially waived your right to appeal. But for a little sliver, malfeasance, arbitrator exceeds his authority, and the arbitrator's authority comes from the collective agreement. So his or her authority is whatever you say it is. And most of us are pretty careful about that. It's tough to have an award appeal. I don't know, I've heard 500-600 cases in my career. I've had 3 or 4 appealed that have never been overturned. So, I mean, it's rare, and most arbitrators have never been overturned. So what happens then is that once you're under this statute, now there is a very strong compulsion to get the thing over with, finish, no appeal, which is one of the reasons it saves so much money, why some people say it's sort of quick and dirty, but it is faster, and you get a decision, you're not left hanging for years on a time and in the appeals court. To sort of get back to the background of this, and we know that there was this impetus. I think it came largely from employment arbitration, and I think the changes blur the distinction between employment and labor arbitration to the detriment of labor arbitration, in my opinion. Nonetheless, they sort of snuck through, and even though there is a provision in the law very clearly in section, the employer union exception, which gives you the right to waive the right of a party to agree to arbitrate to be represented by a lawyer at any proceeding or hearing under sections 572B01, except that an employer and labor organization may waive the right to representation by a lawyer in labor arbitration. May waive means both of them have to agree to waive the use of attorneys. That's where the fear of forcing only attorneys to appear in arbitration is coming from.
So if we have a member that decides that they want their lawyer to represent them, both MMB and the union have to agree to allow that under that statute?
No. The individual is not a party to the agreement. The agreement belongs to the union and to the employer exclusively.
Is what you're saying, it almost sounds like you're saying it's expected that both sides will arbitrate with the use of an attorney unless both sides agree to waive that.
That's what I'm hearing too.
Yeah, I mean, statutorily, the provision is, and it's in the agreement, except as otherwise provided. otherwise provided, which is I gave you the one. Parties to an agreement to arbitrate or to an arbitration proceeding may waive or vary the requirements of all these sections permitted by law. But it's permissive. They may waive it. And then it goes on to say, waive the right of a party to an agreement to arbitrate to be represented by a lawyer. Statute says if you want to be represented by an attorney, if you're a party, the parties in the company or the employer in the union, you have that right. Well, you do now, even under your current agreement. I mean, you know, the doer is represented by an attorney.
So where does it, why would we assume that MMB would require us to have a lawyer?
I don't know the answer to that. I mean, that's what bothers me about this, because there is no requirement. There clearly is a bias in favor of attorneys if you read the language that way, but it's not required anywhere. It's still not required. And there's a specific exception for employers in unions where it says, except an employer and a labor organization may waive the right to representation by a lawyer in labor arbitration, the employer and the union. So the employee doesn't get to say, but I want an attorney to represent me.
Got it.
Not there. That's not in the statute. Here's what the fear is, Mike. And you can read it in Christopher Klug's article. That younger, inexperienced arbitrators who are not familiar with the process may be reluctant to stand up to a demand by one party or the other for discovery, for an injunction. I mean, this statute gives arbitrators the authority to do all those things.
But what,
Here's what's going on. The first thing is this waiver provision. And it says, well, the parties can waive it. But some attorneys say, but what if they don't waive it? What happens? Can they tie the procedure up?
Okay, so going back to your example, you've got this inexperienced arbitrator and they're being asked, can we do depositions, can we and there's different motions coming. So how does that affect, how does this new rule about lawyers get affect that?
I don't see how it affects them other than that if you're going to do a deposition, normally lawyers do depositions. No requirement in arbitration. Very clearly under current law, the law based on the Supreme Court's Trilogy decision in 1960, arbitration is a layman's process. And one of the reasons that you can do that is because you're under Resjudicata. We're not worried about appeals. We're not worried about cluttering up the record with objections. I mean, it's, you know, that the arbitrator is entitled to exercise his or her judgment in ruling upon the admissibility of evidence. You know, you can object, and the arbitrator says, well, I'll take it for what it's worth. What are you going to do? Well, we already do that.
Yeah.
You know, that's...
So this doesn't change the trilogy then?
No, it does not, and the Trilogy is clear. It's the implication. I mean, it's a lot of what could happen. After an arbitrator is appointed and is authorized and able to act, the arbitrator may issue such orders for provisional remedies, including interim awards, as the arbitrator finds necessary to protect the effectiveness of the arbitration proceeding and to promote the fair and expeditious resolution of the controversy, to the same extent and under the same conditions as if the controversy were the subject of a civil action. In other words, the arbitrator's got the same authority as a judge
all right.
in provisional remedies, in ordering depositions, in ordering discovery. That is different.
What's the danger? I don't, what's the danger is what I'm asking.
I don't know that there is a danger in
Well,
that.
I don't know that there's a danger. An arbitrator is immune from civil liability to the same extent as a judge of a court in this state acting in a judicial capacity. I love it. The judge, again, under the Trilogy, has no authority to go back and re-look at the facts. The facts are for the arbitrator to determine. Even if the arbitrator's wrong, you've got to live with it. That's one of the problems with arbitrators making legal decisions. You know, one of the maxims is never give a attorney arbitrator a legal question because you might get bad law. Well, you might get bad law from an attorney arbitrator too, and you got the same problem. So, I mean, I don't see that that's an exclusive problem for non-attorney arbitrators. There's another issue that is of concern, and we've talked about the, the discovery area, and that has to do with remedy. You always ask for a remedy to your grievance. What is it you want the employer to do? Typically, you want them to make the employee whole. We talk about make-whole remedies. Those of us that work in this area understand what a make-whole remedy is. It comes out of the National Labor Relations Board's decisions to prefer make-whole over punitive remedies. You try to put the individual back where they were, but for the employer's wrongful act. Well, in a discharge case, that's easy. Make whole is reinstatement with back pay, and you clean the record, and we're done. But in other grievances, sometimes it's tough to frame a remedy. Because we, one, want to remedy satisfy the grievant, but we also want to prevent the employer from doing it again. And so how do you put teeth in it? You win the battle, but you lose the war, and they just go do it again, and now you got to grieve it again. So, how do you stop that sort of thing? Well, some have suggested that the way you do it is through liquidated damages or punitive damages. It's currently permissible where if the parties can show that the other side's actions were willful, intentional, that you can get a punitive remedy. But it's very, very hard to do. And sometimes they say, geez, we'd like to get double back pay, but how do we justify it? Other than as a punitive remedy. Well, under the provisions in the law, arbitrators now have the authority, as do judges, to issue punitive awards. And to award damages, attorney's fees, which arbitrators, we all understand that our job is only to issue make-whole remedies. So I think that's expanded. And there's some fear that you may get some crazy remedies. Their argument is you're blurring the distinction between employment arbitration and labor arbitration. And labor arbitration has a very different history and a very defined area of practice that has been thoroughly reviewed by the courts and has been settled law since 1960. So why do we want to come back and revisit this through a state statute?
Where's the blurring occurring?
The blurring is that we're going to end up treating employment arbitration just like labor arbitration. There won't be any difference. It'll be really the same thing. Because essentially you're going to be in front of a judge and not an arbitrator, or the arbitrator-judge function is, arbitrator becomes a judge, essentially. And the arbitrator has then these additional remedial powers, which makes sense in employment arbitration, but not in labor arbitration, that he has the ability to order discovery, which makes sense in employment arbitration because you got an individual grievant unrepresented by an organization. So the arbitrator can say, yeah, you got to give him this stuff. The arbitration process could be much more legalistic. Again, because of the concerns of the parties about these potential issues, we're going to pay real close attention, and we're going to do at least very legalistically so we don't have any unintended consequences. The result will be to bog the process down, delay it, and take away some of the advantages that arbitration has had. Well, I think simply in summary I would indicate that I think there's more concern about this than there should be. I haven't seen any great rush on the part of arbitrators. I think there is some likelihood that there'll be a modification to the legislation that clearly carves out the exception for labor management, and that's all they want to do. And otherwise, as you say, I mean, these are sort of neutral changes that they may end up harming one side or the other, but it's not apparent from the legislation that that's the case. It's just how it plays out. But it certainly does give arbitrators greater authority, both in terms of discovery and in remedies, and in pre-hearing conduct, where arbitrators, we usually don't get involved until the hearing, unless we're going to issue a subpoena. That's about it. But this could require the arbitrators to convene a pre-hearing hearing and make an evidentiary finding on a procedural matter.
No, I think that's what we're gonna have to do.
That can happen. I believe that can happen under this. So, I mean, there are, as I say, unintended consequences. And it's, hopefully, the legislature will clarify those unintended consequences and say, no, we don't want that to happen. Apparently there was originally language that did carve out labor management arbitration completely. And it got watered down somehow in the final version. And people weren't real vigilant about it, and now they say, oh my God, what did we do? Well, this is what they did.